Welcome back to Blemings Labs. Our final talk for these 2 days in Blemings Labs is Neil McGovern. I'm very pleased to be able to introduce him to you. Neil's going to be speaking to us about patents, and his presentation is Patently Obvious, the year that lawyers came to FOSS. Neil's a long-term contributor to free software. He's held posts on the boards of Software in the Public Interest, Open Rights Group, and served as a term on the Debian as the Debian project leader. Neil currently works as the executive director of the GNOME Foundation. Please, everyone, make sure that you post your questions into the question tab of the Blemings Labs channel in Venulus, and I'll hand it over to you without further ado. Thank you, Neil.
Hi, and thanks very much for everyone for coming along and coming to this talk. So this is a talk about GNOME and how we got sued by what I'm going to call a patent assertion entity. So if everyone will kind of cast their minds back to what seems like a very long time ago now. This was August in 2019. We had a conference in Thessaloniki in Greece. And this was GWADEC, our annual conference, which we have for GNOME. And it was a fantastic conference. We all got to meet in person. We got to hang around in a bar and drink lots of beer with people. I know this might seem like something that's a little bit different from where we are now, but this is a world that did used to exist. In fact, the conference went really fantastically well. We had some great times, and we even managed at the end of it to find a beach. So at the end of the day, we found this fantastic beach in the island of Thessaloniki and popped along there and had a nice relax for the end of the conference. So after this beach day, we wandered back to Thessaloniki, and basically, for those who know Thessaloniki, it's built on a bay, and in that bay there is this what can only be described as a pirate ship. And this pirate ship wanders around the bay, and it's free to go on and you can wander around it, but there is a slight catch, which is you have to buy a beer. It is in fact a floating bar. So being the good British person that I am, I certainly oblige them and go and buy a beer or two as I'm wandering around. Now, what you can't see in this particular photo is just off the edge of that picture is there's a nice cafe with some good Wi-Fi. So I'm connected to this Wi-Fi point. I've got a nice beer. This ship decides to set off, and obviously at that time, I lose my Wi-Fi access because I disappear off. Just before I lose my access, this tweet arrives. So this is mentioning that apparently we're being sued over patent infringements in Shotwell. Now, for those who don't know, Shotwell is an application that we use when we distribute. It's a photo management application, so you plug your camera in and it deals with your photos for you. So nothing particularly exciting or exotic, fairly standard thing there. But apparently we're getting sued over this. Now, I don't really know what to think about this at the time, but as I mentioned, the boat is now leaving and I don't have any internet access. So I now head out into this lovely bay in Greece for an hour, and I lose my internet connection. So that's fantastic. So I've now got an hour when I'm looking at this thing and I have no idea what I'm going to do. So as it turns out, this was a real lawsuit. A bit of background as to who this was, what's going on, and something like this. Again, people who've been around free and open source software a lot before will know that there's a lot of things about patents and how these are, and issues around those. But as it turns out, this particular one apparently is actually a real lawsuit, and we are being sued over it. So, bit of background to who this was. So this was, we were being sued by Rothschild Patent Imaging Limited, which is controlled by someone called Lee Rothschild. This is particularly interesting because Lee Rothschild owns a number of companies, and each of these companies typically owns a single patent. So Lee Rothschild controls over 100 different patents, and so has over 100 different companies, and each of these essentially owns a single patent themselves. So the particular organization we've been sued by is Rothschild Patent Imaging, and this suit was filed on August 28th. Interestingly, in the Northern District of California. Normally, this is patents are litigated in the Eastern District of Texas, which is normally fairly more favorable to those who are suing people over patents. However, this particular case, it was filed in Northern California because that is where GNOME is based. So that made it slightly better for us. And I should note that 5 other organizations were sued at the same time. And for those that are following along at home, this is US patent number 9936086. And this was a patent that was filed in 2017. And the basic idea is this is directed at the process of filtering pictures from a camera. So we had an initial response on when I landed back on ground in Thessaloniki. So obviously I was a little worried. I got in contact with our pro bono lawyer, which we use for some of these things. This is the wonderful Karen Sandler, for those who know her. And she gave me a bit of reassurance that, okay, this is a thing that's happening, but should be okay, and we're going to try and deal with it, and that should be okay. And then basically I headed back off to go home, and I landed back in Heathrow and had an email from Shearman and Sterling LLP. And the Shearman and Sterling are a global law firm. They have offices in over 80 countries worldwide. They've provided services for very many different organizations. And they were very, very kind and emailed us to basically offer their services pro bono for us. So that meant that they wouldn't charge any of the normal fees for lawyers' time to be able for us to defend our case. Now, interestingly, they had essentially noticed that we had that we were being sued. So one of the things they usually do is, so they look through the number of cases that are being filed, especially in California, and they'd noticed that we were being sued over this. And they also noticed that we are a free software project, and that we're a non-profit. And so they reached out to us. We didn't sort of seek them out. They found this case and they reached out to us and offered to represent us. And this was a huge relief for us to have somebody who's quite so large and experienced to kind of back our case, really. So I want to talk a little bit about the actual patent here. So as I mentioned, this is the '086 patent, and the patents which the methods which it covers is enshrined in the top section of the patent. So it's about a method performed by an image capturing mobile device, etc., etc. I'm not going to run through it all. You can read it yourself, or you can go online and have a look at the particular ones. So just to kind of summarize, what we have is here. You plug your camera into your computer, you sort it by some sort of criteria, either automatically or, as it turns out, manually, and then you upload it to another device wirelessly. So plug your camera into computer, select photos from the last month and put them on Facebook, and that apparently is covered by this particular patent. So we thought this was obviously overly broad and a number of other things, but that kind of gets the basic idea. So there's some fantastic figures in the actual patent that kind of covers what this is meant to do. So I had a briefing with Matt, who is our lawyer from Shearman, and we kind of wanted to work out what our initial response would be. So there was a few thoughts that we had going on. So my initial ideas was that this wasn't just about GNOME. To my knowledge, this was the first time that there was an actual court case happening where a free and open source project was subject to litigation in the courts in the US over a patent. And so I was quite aware that this was something that was a bit bigger than just us. Of course, with free and open source software, we've always been aware of patents and how those are affected and how those affect our free software and software in general. But this was a real case. It was assigned a judge, and we were being served papers. So I was aware that this was something that was a bit bigger. I also had a concern that this case was going to be dropped. So previously, when Lee Rothschild had sued people, for example, there was a case against Garmin over I believe some GPS issues at the time. It went through to litigation and pre-trial, etc., etc. And about an hour before the case was about to be heard by the judge, and because Garmin were defending it, Rothschilds dropped the case. And there was nothing. Obviously, Garmin had spent quite a lot of money at that point, and there was nothing they could do about it. So I had a concern that basically, if we stood up, then we get strung along for a number of months, and then just before the case was about to hit, it would magically go away, and that'd be a huge waste of time and money, etc., for everyone. So we wanted to send a message that this wasn't going to be easy, that suing free and open source software projects is going to be costly, and that basically you shouldn't sue open source software because it's not going to end well for you. So my primary aim at this stage was to send that message. So a bit of history, we were sort of served officially on August 30th. I put this in inverted commas because the papers were served to an office that doesn't exist and that we hadn't ever used. So this was sent to an agent in California that we didn't recognize. However, we could have contested that and said we weren't served properly. However, it's fine. There was an active case. We had the papers. I basically found that we got them via Twitter. So whatever, that would have caused maybe another week or two delay, as there was some process to actually serve us properly, but it would have going to be immaterial. So what we then had to do is some assessments with Shearman and Sterling. So one of the things that they're interested in is making sure that we're a proper non-profit, rather than just having a shell and actually secretly having a team of millions of lawyers and millions of dollars in their bank account behind that. That didn't take too long, because I would love to have millions of dollars in the bank account, but we don't. So that went fairly smoothly. And then there's something called litigation holds, which we had to go through, which is basically, I tell everyone who works on GNOME that please don't delete all your emails. Make sure you don't wipe all the details about Shotwell and everything like that, because they might come up in court. So we went through a series of that. So that was kind of our initial response. And I published a very bland statement saying we're aware of what's gone on. We respond in due course. We believe that this lawsuit is baseless. So fairly bland, nothing really to respond. At this point, we get our initial settlement offer. So the initial settlement offer we got was for $70,000. So if we pay Lee Rothschild $70,000, they would drop the case and give us a license for this particular patent. Obviously, we weren't particularly keen on this, because that didn't really sort of suit our aims. Kind of in hindsight, I guess it would have been easier to just settle and pay the thing and have the problem go away. But I felt that wouldn't be right. I mean, it would have caused so much less stress for all of us and so much less work. But I don't want to settle with patent assertion entities. I don't think that's right. And I think we need to send that message that you can't sue open source projects and get away with it. So we declined. As I mentioned, we issued that initial statement on the 25th of September saying, yep, okay, that's fine, we've been sued. There's some interesting effects of this. So one of the things that did happen is that their lawyers, Lee Rothschild's lawyers, got a number of threats sent to them by email. Dear Internet, if you're out there, please don't email lawyers threatening them. It doesn't help, even if it's on the other side. We're all actually the lawyers are actually trying to work together to get something resolved here. Sending threats to the other side does not help, even if you're well-meaning and trying to do this. Please don't do that. A couple of other ones. We also, in this initial stage, we worked with the Open Innovation Network. For those that don't know, the OIN is a group who hold a pool of patents which are used defensively on behalf of free and open source software projects. Unfortunately, in this particular case, that doesn't help, because this particular patent assertion entity doesn't produce anything. What they do is they sue other people over patent infringements, so they don't produce anything themselves. Excuse me. So it's quite hard for them to infringe on anything else. However, the OIN were very, very useful, as we'll see in a bit, on identifying things like prior art. We also identified that we had a license. So through one of the distributors of GNOME, it turns out that they had a license for this particular patent. So in essence, even if we were infringing, and even if it was found that this patent would be valid, we had a license to use it anyway. So at this point, we were feeling a little bit better over our sort of chances of success. So we decided to go public. We filed a number of papers with the court. So Firstly, we answered the complaint. So this is basically saying, yep, we've received this. We don't believe we infringe. We don't believe the thing is valid, etc. And so basically our defense against the particular the case in question. We had a counterclaim to say that we wanted declaratory judgment that the patent is invalid, and then a motion to dismiss. And the motion to dismiss this complaint was basically on the basis that the patent was ineligible for patent protection. So this is particularly interesting because once you have a counterclaim, that means that the other side can't just drop the case unilaterally, because you are now have a sort of countersuit. The judge is, unless you agree, the case is going to go ahead, and it requires the judge to basically agree that the case can be dropped. Interestingly, when all this happened, there wasn't any warning letters. Sometimes the way that patent assertion entities work is they send out a load of warning letters saying, hey, we think you infringe about our patents, please give us some money and we won't sue you. Lee Rothschild doesn't operate like this. What he does is he files real suits, and then offers settlement offers again after that. So we filed a number of counterclaims, a number of motions to dismiss, and a number of answers. We then get and we also put out a public statement, which was very strongly worded, explaining exactly what is going on, and asking basically the public to help us out. We wanted a call for funds to be able to fight this. That was very successful in the end. We received from, I think, over 5,000 people and individuals, over $150,000 in the course of basically a week. And also a huge thanks to Linux Australia. They gave us $5,000 themselves to help us with this case. And I think that, and for me, this was also a really important part of actually the case and the strategy. We wanted to show that if you sue a free and open source project, then very, very quickly this project can gather money, and we can get money together quickly to be able to defend these things. And so it was really, really good to see all of that coming together. Now, as an indication, that is not anywhere near what is actually required. So for anyone who does get sued in the future, to actually fully defend a patent case from start to finish, you're looking at about $10 million. So fortunately for us, our lawyers were working pro bono, so for free, but there's other costs involved as well. So even though the time was free, there's things like filing fees with the court, there's expert testimony, there's things like looking at hotel fees, travel, flights, etc. So there's a number of costs there. So yeah, so we went public, we got spare money, and this was all good. So we're now looking at what we're going to do with this. There's now a phrase called pre-litigation. So this is the time between the papers being filed and essentially our day in court of what we're doing. And this lasted kind of between October and February 2020. So for those who can remember, this is before national lockdowns took place, and we all ended up where we are. So we took this time to kind of sort of strengthen our case before the first hearing, before the judge. And we'd identified a number of pieces of prior art. So this included patents, patent applications, academic papers, and products that were available before 2017. Interestingly, including Shotwell and gthumb. Gthumb is something produced by GNOME, which produces thumbnails and is basically an image viewer. Shotwell is the thing we were being sued over. So this meant the application we were being sued over is its own prior art for the patent we are being sued over. So that's kind of interesting. However, as also I mentioned, we had also identified a license for the patent. So that was all fine. And then we went through looking at a series of depositions. So these depositions is where basically you try and find out information from the other side, either in paper form or interviews, etc. We got a series of requests for depositions for what they wanted information from us, which was around the patent and around the software and what we do and who knew about it when. Our depositions did not mention the patent at all. Our entire depositions and our questions were around Rothschild patent imaging and how it was founded and how it was capitalized and who controlled it. And we were looking for reasons why we should not pierce the corporate shield and make Lee Rothschild personally liable for the entire case and all the costs associated with it. Because we believe basically that Rothschild Patent Imaging was essentially a fake company, and it was set up so if they lost a particular case, that it would just fold and it wouldn't pay any costs, because the company, the shell company, would essentially go bankrupt. So all of our questioning was around how this company was set up and why Lee Rothschild shouldn't be personally liable for this entire case. So, end of February, we were meant to have our first hearing. I flew out to California. I was out there for a couple of weeks. We met with our lawyers, discussed some strategy. Unfortunately, the judge at the time then decided that they were going to conclude the case basically on written arguments only. So there wouldn't be an oral argument. They'd just do it via paper, which is fine. But we then had our third settlement offer from Lee Rothschild. And our third offer that they sent us was that essentially we both walk away on a own costs basis. So that meant basically we pretend this never happened. Obviously, we weren't particularly happy about this. We'd spent a considerable amount of time, so we politely declined. And we counteroffered. What we counteroffered was, okay, I'll tell you what, if you give us a covenant not to sue us ever again for any of your patents, and you give this to all of free software forevermore, then I'll tell you what, you can keep your patent and carry on suing proprietary people. We don't care, as long as you don't sue any free software for anything ever again. Our lawyers did mention that this was a very nice idea, but would never get it. Right? It's like, yeah, okay, but it was a position that we were going to take. That kind of showed where we were and what we need to do. So, fast forward a few months. I'm aware that we've got not that much time left. So I'll just briefly cover what we wanted and what we got. So our key red lines here. We needed to be able to say we didn't pay him anything. And we didn't. We needed to be able to prove what we obtained in this settlement agreement. So if you have authored any particular piece of free software, any significant piece of free software, you can email me at director@gnome.org or neil@gnome.org, and I will send you a copy of the settlement agreement. Normally, settlement agreements are confidential and they're subject to NDAs. In this particular case, I wanted to ensure that it wasn't, so that people could actually see and be able to verify what we'd obtained. It needed to apply to all of free software. It needed to follow the patents if sold, and needed to cover all of their portfolio, and also cover any future patents. The reason this then took so long is there was a series of issues that we went through. I think we returned to litigation about 3 times. However, we did reach a final agreement. And this net effect is that you have protection for all of free software for over 100 patents. This particular covenant not to sue follows the patents. So if they're sold, they still can't affect free software. If Lee Rothschild himself invents any more patents or acquires any more patents, he personally cannot sue any free software project. And we've essentially removed the ability for this particular patent assertion entity to sue any free software ever again over their entire patent portfolio or anything they should acquire in the future. American lawyers found this to be quite extraordinary, and I think this is something that doesn't happen ever in patent cases. And they named our lawyers litigators of the week. So that's Matt, Kieran, and Joy from Shim and Sterling. I think as a community as a whole, we owe them a huge debt of gratitude for everything they've done. So I think we might have a couple of minutes left for questions. If there is any, I'll happy to take them. Otherwise, I'll hang around in a couple of the chat things and hopefully be able to talk to people there as well.
Thank you so much. We did have really fantastic talk, and what a journey. We did have a couple of questions in the chat, but we do only have 2 minutes to go. So what I might do is the 2 questions are, were you able to claim from the patent troll for your expenses? You covered a little bit about at least mitigating that, but did you get any damages or anything from them?
Unfortunately not, no.
Okay.
Because it was... We didn't pay them anything, but one of their things is they didn't want to pay us any money for it. And
okay,
in settlements, you have to come to a middle ground. So, yeah.
For sure. I'm actually going to ask a slightly roundabout one, and then I'm going to have to close, which is, so some jurisdictions in the world are shifting to the notion that software is not patentable as a general. That's obviously UK case law has driven that, and huge shout out to the New Zealand Open Source Society, who managed to get software defined as simply not an invention, except for hardware software. Anyway, I guess with jurisdictions having inconsistency on this topic, how do you think FOSS projects, because we're global by nature, can address those global inconsistencies in law?
So partly it depends where you're constituted. So if you're based in the US, then you're subject to, in some ways, you're subject to US law. In other ways, it doesn't matter, because we could be constituted in the UK and we could be sued in the US. I mean, we need to continue lobbying for patent reform and making sure things happen. In essence, where you are subject to the lowest common denominator, because you can get sued anywhere in the world. So that's kind of where you are. Your main issues that you actually need to look at is the major patent markets. So US, Europe, and Australasia.
Okay.
They're main areas.
For sure. Look, thank you so much for the talk. I'll ask everyone to please continue the conversation on the Blemings Labs post-talk Q&A session. And if you wouldn't mind joining us there, Neil, to follow up in conversations. Because this is the last talk for Blemings Labs in this virtual room, I just wanted to say it's been a really big couple of days, and I wanted to quickly take a moment to actually thank our Blemings Labs team. So the Wranglers, Karen Moskell and Kylie Willison on AV. We've had a sterling job from Daniel McCarthy, Justin Liu, and Michael Farrell. Stephen Thorner on, Tom? Thomas, I just know him as Stephen Quall, on as our first monitor, and Tony Bilbro on as our second monitor. It's been really great to see the acknowledgements to country from everybody, and my own quick acknowledgement to country is to the Māori people and culture here in New Zealand, Aotearoa, and the role of Te Tiriti in for the New Zealand society. And next is a 15-minute break, and then the conference closes back in the Tux Theatre. So we'll see you all back there. Again, thank you, Neil, so much. Really appreciate it, and we'll see you in the channel.
Thanks very much, everyone.